You're tuned in to Agriculture Today, and on this Monday, we begin our show with an ag law update. And in to do that update is K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us once again.
Good to be with you, Shelby.
So today we're talking about Swampbuster rules, which is something I had personally never heard of, but it is something that came with the 1985 Farm Bill. So what are these rules?
Well, you're right. The 1985 Farm Bill brought in the conservation cross-compliance rules. And in a nutshell, what those rules required was that a farmer, to be eligible for farm program benefits, had to have a conservation plan for the farm. And so we got all types of conservation programs that came along with the 85 Farm Bill, including the Conservation Reserve Program and including the Swampbuster rules. So what the Swampbuster rules basically said was that you can't convert a wetland, and that's going to be the key term, to crop production if you want to receive farm program payments. And there were only a couple of minor exceptions to that. One was for prior converted cropland. In other words, if you had already converted a wet area or what's deemed to be a wetland to crop production prior to the effective date of the 1985 Farm Bill, that was okay, but again, that led to litigation on that particular issue. But that was one of the exceptions. But basically, the Swampbuster rules say don't touch the wet areas, don't convert them to crop production if you want farm program benefits.
1985 was quite a few years ago, so a few things have changed since then, and there have been some new rules. What are those new rules and kind of adaptations to what was put in 1985?
Well, some of the initial rules that were put in defined what a wetland was, and you had to have three characteristics. You had to have hydric soil and hydrophytic vegetation or hydrophytic plants, plants that would grow in a wet area, and wetland hydrology. You had to have all three of those. So it was soil type and vegetation type and hydrology type that defined what a wetland is. And then in 1996, Senator Grassley from Iowa, who is still a senator from Iowa in the U.S. Senate, dealt with an issue by amending the Swampbuster rules to say that a delineation that's been made by NRCS of a wetland for a farmer couldn't change unless the farmer requested a new delineation. What was happening in the early 1990s, about 5-6 years into the Swampbuster rules, was that NRCS started using aerial photography to delineate wet areas and areas that would be wetlands. And so you'd have a previous delineation that would suddenly change on a farmer, and what was not defined to be a wetland now is defined because of aerial photography. And it was creating all types of uncertainty for farmers. They would start planting, here comes a new delineation, now this is a wet area, and they would have the rules change on them suddenly. And so Senator Grassley came in and said, no, you can't do that. We're amending the statute, and so this is a statutory change, and said that a prior wetland certification shall remain valid and in effect until the time that the person affected by the certification requests a review. And there was no mention, that's the end of the statutory language, there was no mention of giving the NRCS the ability to write regulations to carry out that rule, but they did. USDA developed a regulation known as the review regulation that set up procedural requirements that a farmer had to follow to make an effective review request. In other words, they were saying, well, you can't just request a review of us at any given time. You have to show that some type of natural event had altered the topography or the hydrology of the land, or you have to show that we made a mistake, or we admit we made a mistake. So those were the two conditions to getting a review. But otherwise, the statute said that NRCS had to do a new delineation if a farmer requested it.
And that kind of tees us up perfectly into a case you want to talk about called the Foster case.
Yeah, this is a case involving Arlen Foster. He and his wife, Cindy has since passed away. But they farm northeast of Mitchell, South Dakota, so kind of in that southeastern quadrant of South Dakota, rich farming country. And this has been held in Arlen's family for many, many years, almost 100 years. And in fact, back in the 1930s, with some of the initial farm programs, his ancestors were told by the government that there needed to be conservation trees put in to help protect the soil. This was in the days of the Dust Bowl and so forth. So they did plant these trees. And, of course, now those are very mature trees. And what happens is that the snow in South Dakota will build up next to and under those trees and then slowly melt in the springtime and would pond in the middle of the field and created what NRCS said was 0.8 of an acre of a wetland. And he couldn't do anything with that excess surface water. It was not attached to any type of drain system at all. There's no tile drainage. It doesn't drain into anything. It just kind of sits there, saturates the soil, and slowly has to evaporate and then saturate down into the soil before it becomes dry enough for him to plant crops, which about half the time, half the cropping seasons, he can't crop that area. It's just too wet unless he drains it out, manipulates it by getting the water out of there. USDA came in and said, that's a wetland, you can't farm that. By the way, you did, you're in violation of the farm programs, and you have to pay back benefits that you've already received. So he requests a redetermination pursuant to the Grassley Amendment. He did this along about 2008. That gets rejected. Comes back a few years later. He has an engineering report this time that had said that it's not a wetland, according to the civil engineers, and he had data provided that showed that the soil type, because one of the requirements to be a wetland, as I mentioned, is you have to have hydric soils. Well, the soil type of this particular area was not a wetland by NRCS definition. It was a different soil type. So it wasn't hydric soil. And you have to have all three of those requirements to have a wetland. And he's showing that, look, they don't satisfy one of these, so it cannot possibly be a wetland. Well, what happened was on the second go-around, NRCS basically didn't look at any of the data and said, well, you haven't shown any changed circumstances, the topography is still the same, therefore the redetermination is denied. And then that's what happens. It gets into court.
And this is something that started in 2008. However, it continued for many, many, many years and is kind of still going on today.
Yeah, the court said that the NRCS, he was challenging the ability of the NRCS to even write a rule because the Grassley Amendment does not say that the government has the right to write a rule here. But the court said that the NRCS could write a rule specifying conditions for review and that the rule they wrote was reasonable and that Mr. Foster hadn't provided evidence of changed conditions that would justify a redetermination. And you're right, this has been going on for in excess of 15 years. And now the question is, he's got several options here. One, he could request the full Eighth Circuit to hear the case rather than just the three-judge panel that issued the opinion a couple of weeks ago. Or he could petition the U.S. Supreme Court to review it, or he could just say, I'm done with this. And so those are his three options at this point in time.
And this is obviously an important topic for Foster. However, this is also important to Kansas and the whole United States because these laws and rules affect everyone in the United States. So what's a big takeaway for farmers?
Yeah, they do. That's a good point. And we actually have had Swampbuster cases come out of Kansas. So it's not an issue that's unrelated to Kansas. But anytime you've got surface water or a very shallow water table, you can get into these types of issues. But the broader issue, which will affect Kansas farmers, not just on the Swampbuster issue, but any time a farmer deals with an administrative agency, and it's usually for farmers in Kansas, a sub-agency of USDA, but any type of government administrative agency, you first have to go through their review process, probably lose that, before you can get to a court. And the standard a court uses to review an agency rule is one of high deference. It's a very deferential standard. In other words, the agency is almost always going to win unless their rule is completely unreasonable. It has to be arbitrary and capricious for the farmer to win and knock that rule out. Now, that's an important point, and it goes to the litigation strategy that a farmer might have. And it's an important point because just a couple of weeks ago, the U.S. Supreme Court said that they would hear a case on the deferential standard given to government agencies. So that case won't be argued until this fall. We won't have an opinion until next year. And that could have a major impact if the court changes the rule on the standard of review for government administrative agency action for farmers and ranchers. And so we'll see what happens. But this case, it points out how difficult it is to do battle with a sub-agency of USDA.
And Roger, if people would like to read more about this topic, where could they do that?
There are two places. One is my blog, which can be found off the homepage of my website, which is washburnlaw.edu/Walter. Also, I share a lot of these, including this blog article, to the Ag Manager site through the Department of Ag Econ at K-State.
Roger, thank you so much for coming on and giving us an ag law update. I appreciate it.
Thank you, Shelby. My pleasure.
That was K-State and Washburn law professor Roger McEowen discussing the Swampbuster rules and the Foster case. His article will be linked in today's show notes, which, as always, can be found on agtoday.net.